Welcome to the Smith Family Foundation debate series. Tonight's debate is on the Constitution, and our moderator is Francis Menton, who is sometimes known as Buddy. He is a partner of the very prestigious law firm of Wilkie, Farr, and Gallagher. He's in the litigation department, which usually means those people are usually articulate, right? So he specializes in complex and technical commercial litigation, principally contract and security law. He's traveled and had cases all over the United States. He's the author of Can You Protect Yourself Against Identity Theft and the Top 10 Federal Government Efforts to Suppress Free Speech. He graduated undergraduate from Yale and saw the light, and then got his law degree from Harvard. So
he'll live it down.
Let's welcome the moderator, Francis Menton.
Thank you, sir. And I must admit that as a humble commercial lawyer who spends my days representing companies in disputes over money, I am really appreciative of having this opportunity to get involved in a discussion of some of the really serious and deep issues of the day, really things that there's nothing more serious than this. I was thinking as I got ready for this that in my career I've had a few cases that got beyond the trial court stage and the appellate court stage, and a handful where I've actually written a cert petition, that's a request to the United States Supreme Court to ask them to hear the case and undo it. And essentially the Supreme Court has laughed at me in each of those cases and said, we don't deal with the kind of issues you deal with. The kind of issues the Supreme Court deals with is the kind of issues we're here today to deal with. So we all focus in our day-to-day lives on the issues at hand, which can be daily and humdrum, but in the law, there really are no bigger questions than the questions that are about to be addressed by our debaters. Questions like, what are the powers of the United States government? How far do they go? Is the United States government a government of unlimited powers or of enumerated powers? And if it is a government of enumerated powers, what are those powers, and how are the boundaries on the enumerated powers determined and enforced? And similarly, with regard to the state governments, what restrictions does the United States Constitution put upon the powers of the state governments, if any? I took constitutional law in law school, and in my constitutional law course, which, by the way, was taught by a man named Tribe, who some might recognize, he became famous in the Bush v. Gore cases, the answers to the questions that I just posed were considered basically to be extremely settled. And in fact, those very grand issues of constitutional law were little discussed in my constitutional law course compared to questions of the details of First Amendment law, how many creches and menorahs can you have on the town green and so forth, which the Supreme Court spends a lot of time on today. But the grand questions were considered to be remarkably well settled and not so much discussed. Richard Epstein comes along to point out that 100 years ago, the situation was similar. Those questions were considered to be pretty well settled and not too much discussed, but the answers given seem to be more or less entirely different. So over the course of 100 years, much changed. If I could mention just a couple of things in the world, from a world in the 1800s or the early 1800s where the Louisiana Purchase and whether the federal government had the right to do that was considered a gigantic issue and much debated as to whether that was within the federal government's powers. We went to a situation in the 1930s where the debate over Social Security was basically a debate over how do we blow this by the Supreme Court, but still something they were very worried about, to a situation in the 1990s where the United States Congress passed something called the Gun-Free Schools Act without so much as considering whether it had any power to do such a thing under the United States Constitution, or where it came from, or making any investigation or findings. So here we have a series of questions which in most of the legal world today are considered to be fairly well settled, and then we have certain people out there who I might refer to as troublemakers, who come along and say, maybe the answers that we've come to today aren't really the right answers, and we should look at the answers given previously and see if they might have made more sense. So high in the troublemaking category, I would put Professor Richard Epstein of the University of Chicago, who's here to be our first speaker. And as you probably know, he has written a book called How the Progressives Rewrote the Constitution, which seeks to reintroduce to the constitutional debate some of the propositions about the proper limits under the Constitution on both federal and state power that others think have been well resolved and long put behind us. Here to debate him on some of these topics is Dean William Treanor of the Fordham Law School. And let me just give some brief biographical information on both of our speakers. Professor Epstein is the James Parker Hall Distinguished Service Professor of Law at the University of Chicago, and numerous other titles, and has written several books, a number of which I have read, and people find me a little odd for doing that, but I recommend them to all of you, including Takings and Simple Rules for a Complex World. Some think he's a kook, but I will tell you that he will stretch your mind if you read his books, whether you agree or disagree with him. Always fascinating. Dean Treanor of the Fordham Law School has been on the Fordham faculty since 1991, had positions in the government, including Deputy Assistant Attorney General in the Office of Legal Counsel. It's a long title, but it's actually quite a fancy position in the Department of Justice in the late 90s in the Clinton administration. And his scholarly work focuses on constitutional issues at the highest level, including an article in the Columbia Law Review on the original understanding of the Takings Clause, and another article on the new millennium of Lochner. For those who don't know that, Lochner, a famous Supreme Court case from 1905, which features prominently in Professor Epstein's book, and Dean Treanor has also written an article on it. Some might consider it among what Professor Epstein calls the progressives. Some might call it the most reviled of all decisions, maybe with the exception of Dred Scott. Professor Epstein seeks to revive it. Dean Treanor is a graduate of Yale College and the Yale Law School. So with that, the rules of the game here are that each man gets approximately 10 to 12 minutes for an opening statement, 5 minutes for a rebuttal, and then I get a question and answer period to round out the hour, and then after that, you get a question and answer period. With that, the proponent of this debate, Professor Epstein, gets the floor. Thank you.
Very nice for me to be here. Being called a kook is, I think, a term of high praise, and so I wish to thank you for that kind introduction. Others have said it without the smile at the edge of their lips, and to those people, I just hope that they will reconsider. The topic of this particular debate is, in some sense, how the progressives rewrote the Constitution. And I think in order to understand what this topic is about, you've got to think of it in two ways. One of them is a matter of text, what the Constitution provides, and the other, which is somewhat more elusive and more difficult to deal with, is the question of what kind of government do we want and how we reconcile that vision of government with the text. And here it seems to me that you're probably better off starting with the basic theory of the original Constitution and working back to the text rather than the other way around, because what happens is there is surely a very powerful transformation from the Lockean ideals of limited government, which animated the original Constitution, to the sort of social welfare ideas of comprehensive government, which essentially animated the New Deal changes. Now, why is it that the original Lockean provision was one which had, shall we say, a skeptical view towards government? Well, it wasn't completely hostile because it realized quite clearly that you could not run any kind of society unless you had some monopoly of force which would allow you to stay the violence that would otherwise take place between self-interested individuals. So that's great. You set yourself up some kind of a sovereign. At that point, you then have to ask the question, what's to prevent this fellow from becoming a worse transgressor of individual rights than the individuals whom it's now going to govern? And that was the challenge that was set by Thomas Hobbes. And the answer to that challenge came in this fashion. No, we don't want to assume that everybody who governs will act in good faith. What we do want to do is to put into place a whole variety of restraints on what governments can do so that you always have the cat chasing its own tail. There's nobody who owns all the keys to the kingdom, and by dividing and separating and slicing power up in this, that, and the other way, you could prevent the real dangers of excessive government power while allowing for the maintenance of order, the provision of infrastructure, the control of monopoly, and the like. And it seems to me that a theory like that has a lot of good because of one basic economic proposition, is try, and however clever you may be to argue it, when you're dealing with the behavior of individuals in this sort of grubby commercial sense which certain named moderators engage in, it turns out that you do a lot better in competitive markets, even with litigation, than you do in monopoly markets or regulated markets without them. This is not the whole truth. There are certain things like network industries where it doesn't apply, but in lots of cases, if you unleash creative powers by private individuals, you're going to get higher levels of output. So the great question is, how do you manage to create a system which allows for the flourishing of competitive markets on top of a system which has in it a strong element of monopoly government? And we've come up with three answers to that question in the original founding period, and I think they sort of, well, basically don't survive to the extent that they really should. One of them is the principle of separation of powers, in which you have a Congress, an executive, and a court, and you constantly try to parcel out the powers. And for those of you who follow the national security debates, the division of power between the president and the Congress is very much at the top of that. When you start to deal with economic issues, however, the central question is often that of federalism. One way in which to limit state power is to put states in competition with one another so that if one state becomes too oppressive, then individuals will be able to take their firms, their businesses, and go somewhere else. And competitive federalism will allow that to happen so long as you do not have a national government can absolutely overwhelm by creating regulations that are uniform across all states. So weak national regulation is, in fact, in competitive industries a benefit, because what it does is it neutralizes the most dangerous sovereign of them all, the federal government, and it certainly places checks on the states, because now they have to provide services for the regulations they impose, or otherwise people will go elsewhere. Now, it turns out you can't always go elsewhere. For example, land can't move. And so one of the things that you have to do is to also figure out ways in which you could protect those immobile resources. And we have protections against the taking of property, for example, which are designed to achieve those particular goals. So that what happens is, in the original situation, you're constantly worried about government, not as being overtly hostile to it, but as being respectfully suspicious of it, trying to limit it, saying in effect that the presumption is against the use of its power. Well, how does this stuff cash itself out in practice? Well, essentially, on the federalism level, the largest grant of federal power is the Commerce Clause, which says Congress shall have the power to regulate commerce with foreign nations, among the several states, and with the Indian tribes. And the question you then immediately have to ask is, what do you mean by commerce? Now, as a textual matter, the word was clearly, in its original understanding, understood in opposition to the terms manufacture, production, and so forth, or agriculture and mining. And so what happens is that the states would have exclusive power to regulate those activities, and since people would then sell their goods into competitive markets on a nationwide basis, the function of the federal government would be to organize the channels of commerce. And for the most part, it has done a pretty good job, to the extent that it had only limited powers, in making sure that there would be a free and effective shipment of goods back and forth across various state boundaries, which helped to create the might of the United States by creating a general economic market. And this position is really quite old. It goes back to a case called Gibbons and Ogden, where Justice Marshall took the position that a state monopoly, which was granted to Robert Fulton over the waters in New York State, could not block a transportation by another company from Elizabethtown, New Jersey into New York waters. The interstate interest dominated the local interest under these circumstances. Now, the second element, in addition to this, had to do with individual liberties. And here the great issue had to do with the impact of industrialization on the relationship between employers and employees, between large firms and little buyers. And the traditional classical response under this was that these large firms would be bound by the same rules as everybody else. They could not lie or cheat or coerce, but they could try to undersell their rivals. And the constitutional order in dealing with these situations went to say as follows: you could regulate with respect to health and safety, general welfare, and morals. But these categories were not regarded as exhaustive of all possible areas of regulation, because the one thing you could not do under these circumstances was to impose anti-competitive regulations on various kinds of firms in order to give one kind of business an advantage over another. The case of Lockean, New York, which has celebrated its centennial last year, was in fact a situation where just that was happening. You had a statute that was passed by the organized bakers and unions, which called for a maximum of 10 hours per day. Its clear effect and intention was to drive out of business non-unionized bakers who worked long shifts and slept on the job, and therefore were always in violation of the statute. And the reason why I thought the decision was correct is because what it did is it made sure that alternative modes of production, unionized and non-unionized, single shift and double shift, could act in competition with one another instead of having one form of government relation dominate and strike out the opposite. Now, when you come to the progressive era, the philosophical backgrounds are radically different from the temperate, cautionary view that you take of government. Now, in effect, if you read people like Felix Frankfurt and Louis Brandeis, both of whom eventually served on the United States Supreme Court, the worlds of industrialization transformed all of the initial understandings of the Constitution and required a radically different approach to the subject matter. Frankfurt was openly contemptuous of Adam Smith, saying that the rules about bargaining that work between the butcher and the baker at the corner don't work when you start having large industrial corporations. They said, in effect, you can't have this system of state regulation when you have large national corporations. You have to have collective bargaining, minimum wage laws, and so forth. And if you want to impose these things on the state level, these evil firms will simply relocate into another state. And so what you have to do in order to make sure that you can control the bad forces of industrialization is to have national government operate at both levels. And true to their basic premises, the progressives were remarkably consistent in the way in which they imposed their particular outlook on the country. On dealing with the question of the Commerce Clause, for example, all the stuff associated with enumerated powers simply disappeared from view. It turned out that manufacture was part of commerce, as was agriculture and mining, rather than something that happened before or after. In 1935, there was a case called Schechter, where one of the worst of the New Deal programs requiring maximum hours, minimum wages, and the sale of sick chickens was in fact struck down because what it purported to do is to regulate the movement of goods after they landed in local commerce. 2 years later, when the National Labor Relations Act came up, all of a sudden, Justice Hughes, who had written the earlier position, changed his views and says an integrated market means that everything that affects commerce is in contract, is in commerce. Everything, of course, affects commerce. What's the net effect of all of this? To the progressives, at least at the political level, it was to create, by virtue of national regulation, a system in which you could be responsive to the dangers of industrialization. But that was simply window dressing for a much more ominous trend that lay beneath the surface. Every single progressive reform that brought forth a constitutional challenge was an effort to create a monopoly in somebody, whether it was in labor unions or later on in the great case of Wickett and Filburn in agriculture by creating minimum prices that could not be eroded by intrastate sales or home consumption. So the federalism point of the old guard was in fact correct. Once you start creating huge national powers over manufacture, it's no longer going to be used to open up the wheels of Congress or commerce. It's going to be used to close them down. And the same thing I could be said is true with respect to the way in which you deal with the various issues concerning individual rights. The Lockean Court tried to deal very carefully with the distinction between health measures, which were not regarded as anti-competitive, and labor measures, which were, and they were struck down, for example, statutes that required collective bargaining at either the state or the federal level, because those are statutes which require a firm to deal with a unionized group which has monopoly power. I thought those decisions were correct. If you look at Felix Frankfurter, the only question that you have to ask is, what form of insanity is it that would lead anyone to oppose collective bargaining? The man was absolutely out front and center on that issue and was willing, in effect, to sacrifice all forms of civil liberties, including the ability to associate in religious organizations, simply to get that particular agenda through. And by heavens, when the thing came up to the Supreme Court, all of the individualist arguments disappeared, and what you started to do is to have a full range of statutes with unions, fair labor standards, and so forth. And yet, whenever you see the word fair in a New Deal statute, you must understand exactly what it means, which is that competition will not work in this industry, and that the state will, in effect, state minimum terms on hours, on wages, or whatever, so as to make sure that some kind of a cartel arrangement can take place. So why is it, in effect, that I think that the progressives, when they rewrote the Constitution, did a bad thing? Well, essentially, the indictment comes in two forms. First of all, if you look at the particular provisions of the Constitution relative to its structure, it's clear that they're playing fast and loose with both of these things. Commerce does not mean manufacture. Liberty includes the ability to dispose and to enter into commercial transactions, and you can't read it the other way. The police power cannot be read as an implied exception to the Constitution so broadly as to sweep aside any particular protection in the Constitution. So what is it about my position, therefore, that makes me kooky and radical? Very little, I'm happy to say. It's the kind of situation in which, if you look at the way in which, for example, First Amendment law has been worked out, people are very conscious that government has the right to control force, fraud, and monopoly, and all of those forms of regulation are permissible in connection with speech. And the basic program that I have on the liberty side is take that particular mindset and apply it to economic liberties, and you will get the same kind of benevolent results. On the federalism question, I think the right answer, if you know the modern theory of economic regulation, is this. For network industries like telecommunications and railroads and airplanes, you're going to need a form of federal regulation which you could have under the version of the Constitution as it existed in 1787. But with respect to competitive industries that operate out of local sites, every sensible economic approach to the subject says single forms of regulation are not productive of sane operations, but rather of government mischief. So what I would like to say is this. I think that the intellectual framework of the Frankfurters and the Brandeises of the earliest 20th century is hopelessly antiquated and completely immature. And to the extent that one understands, I think, a greater awareness of the commercial side of litigation, and I have to confess I came to this as a contracts lawyer too originally, you would realize that the generative power of voluntary exchange is the primary objective of government under these circumstances, and the progressives, to the extent that they interfered with that mechanism, on both their jurisdictional and their views on personal liberty, made a mistake, and I only wish that we had the power to undo it today. Thank you.
Very good. 14 minutes, very good. Dean Treanor.
Thanks very much. I'd actually like to begin by thanking the Smith family for fostering this kind of serious public debate, and Aaron Russell, a Fordham Law School student who put this together. And I'd also like to thank Richard Epstein. I've spent my whole academic career writing about private property in the Constitution, and but for Richard Epstein, nobody would care. So I'm very grateful for all of his work, even as I disagree with most of it. Now, we have, kind of at a basic level, we actually have a similar approach to the Constitution. I think both of us are really, at our core, originalists. In other words, his project, like mine, is really to recover the original understanding and to apply it today. So not like Dworkin, for example. It's really about recovering the original understanding. And our disagreement is over what the original understanding was with respect to private property in the Constitution. And specifically what he argues in his book, I'd like to hold it here, Progressives Rewrote the Constitution. It's a great read. He argues that the original understanding is consistent with what he calls the old court, which is the Supreme Court before 1937, before it shifts to the left, and that the progressives departed from the original understanding. And what that really is it's striking, and it's really a flip from the way in which the progressives presented themselves. In other words, the story that they told was that it was the old court that had departed from the original understanding of the Constitution, that the original understanding of the Constitution was reflected in the great Marshall Commerce Clause decisions, which are very expansive. And so they were the true heirs of the founders. And Professor Epstein, in his book and in his talk here, argues that that's wrong, that it was really the old court. And if I could quote from the book, the progressives, quote, seized the opportunity to rewrite a constitution that showed at every turn the influence of John Locke and James Madison. In so doing, they violated the first rule of interpretation. If you disagree with the original text, then you cannot mend your disagreements by adding to its basic rules some exceptions that change the tenor of the document. The progressives were wrong on constitutional interpretation because they consciously used their intellectual powers to rewrite, not understand key provisions of the constitutional text. And that's what I'd like to focus on, the original understanding. Now again, his book has 2 points, really. One is that the old court was consistent with the original understanding. And the second was that the old court is right as a matter of substantive policy, substantive political theory. And my purpose is not to get into that. Professor Epstein started today. One of the questions he said he would look at is what kind of government do we want? And for me, I think that's already been decided. That's the original understanding. And so the question is really just what the original understanding is. And what I'd like to focus on is, I think there are really kind of 3 tacks that are relevant. One is the text and the specific constitutional provisions. The other is what the original understanding of judicial review was, because what Professor Epstein is arguing for is really a very aggressive approach to judicial review. And the third is what is the background understanding of the Constitution? What is the ideology of the Constitution? So let me start with the text. There are 2 key textual provisions when you're looking at what kind of protection does the Constitution provide for private property. There are 2 substantive provisions that are on point. One is the takings clause. Nor shall private property be taken for public use without just compensation. Now, to go beyond I think it's implicit in his book and implicit in his talk, Professor Epstein really famously has a very broad reading of the takings clause, which he grounds in the original understanding. And in essence, it's that property in the takings clause is about value. So when I teach this in class, I say there are 2 ways to think of the property clause. One is property is stuff. The other is property is value. His idea is that property is value, nor shall private property be taken for public use with just compensation. When government diminishes the value of property, it's a taking, unless some other justification like the police power comes into play. And he argues that that's the original understanding. That's Lockean, that's what it's about. That's what the text is. He keys in on the word property. My counter to that on the takings clause is that we have 2 different definitions of the word property. Property is value, property is stuff now, as it was in the late 18th century. But the key word to remember here in construing the takings clause is take. Nor shall private property be taken for public use without just compensation. And that connotes a notion of physical action, physical control. the Takings Clause at its core is not about regulation, which is 100 years of Supreme Court jurisprudence is on point. But it's not at its core about regulation. It's about eminent domain. So, just as an example, my children, Liam and Catherine, are here. Liam is 10, Catherine is 8. If one of them were to be playing ball in the house, and I were to say, Liam, Catherine, do not play ball in the house, they would not respond to me that I had taken their ball because I had deprived them of a value that they particularly prized. Take is physical seizure. It's not just about diminution in value. And that's the way the first 100 years of the Supreme Court of takings law is. It's about eminent domain, not regulation. So at its core, the Takings Clause is about eminent domain, and it's very narrow. It's also not a generative principle. As a matter of fact, if you look at the Bill of Rights, of all the clauses in the Bill of Rights, it's the only clause in the Bill of Rights that no state ratifying convention asked for as an amendment to the Constitution. It's there because Madison put it into his proposed Bill of Rights. I'm not trying to read it out of the Bill of Rights, but it's not at the core for the founders. It's not one of their core concepts. And the other, so Takings Clause, the other kind of core textual provision in the Constitution about protection of private property rights is the Contracts Clause. And again, it's on all fours with the Takings Clause. The text, no state shall pass any law impairing the obligation of contracts. Again, this is really not at the core for the founders. Actually, its place in the ratification in the Philadelphia Convention, it's really shrouded in mystery. Actually, when it's proposed, people reject it. And they opt instead for a bill of attainder ex post facto clause. It's then inserted by the Committee of Style, which is supposed to be just doing style. And people are not sure why nobody notices afterwards. And one of the leading constitutional historians, Forrest McDonald, has said, it was really at the end, and they weren't really focused in August on all of the details. But the bottom line is it's not something that was really at the core for the founders. And again, one of Professor Epstein's basic arguments about the Contracts Clause is that it applies prospectively as well as retroactively, which was something that the Supreme Court, as he acknowledges, rejected in 1827. So he embraces the minority opinion of Marshall. But it's not, the view of the Takings Clause and the view of the Contracts Clause that he argues is inconsistent with the original understanding. So in terms of text, limited protection, limited scope, point one. Point two, judicial review. What's the original understanding of judicial review? The original understanding of judicial review is strikingly deferential. I actually just wrote an article that looked at all the cases before Marbury, and there are many more of them than people have thought. There are actually 31, which is about 5 times as many as people thought, but they're very limited in scope. They're about juries. They're about the powers of the court. Federal courts actually with striking regularity invalidate state government actions that implicate national powers, and that's it. There's really no kind of substantive review that leads to invalidation of statute. None of the 30 cases involves that. As a matter of fact, the one case that's really the most relevant in thinking about what the founders' vision is the case of Ware versus Hilton, which involves the direct tax clause of the Constitution, which says that you can't, no direct tax shall be laid unless in proportion to the census. A carriage tax, a tax on carriages, is laid down. It strikes me that it's really kind of a quintessential luxury tax. It's really very problematic in terms of the text of the direct tax clause. It looks like a direct tax. But the Supreme Court, really in order to empower the national government, unanimously upholds the statute. Okay? So judicial review, very deferential, particularly in the kind of areas that Professor Epstein focuses on. Third and final point, he says the founders were Lockean. This is something that historians have not argued for about 50 years. Now, the orthodoxy is that there are elements of Lockean liberalism, but elements of republicanism as well, which is a very different approach to private property. In fact, stresses virtue, not property, and supports regulation. What's some evidence that the founders were not consistent Lockeans? Well, in part, it's the fact that that judicial review is not in the origins of the Constitution about the protection of individual liberty. It's also evidenced by the fact that protection of private property in the Constitution is so limited. So those are the three basic points. The founders were not the pure Lockeans that Professor Epstein argues that they were. Protection for private property in the Constitution was very limited, and judicial review was very deferential. So did the progressives rewrite the Constitution? I think they had it right. They were, in fact, restoring the original understanding.
Thank you. Well, under our rules of engagement here, each of our speakers now gets a 5-minute rebuttal to rebut the points of the others. I will leave it up to them whether they use the microphone at their seat or return to the podium. So, Professor Epstein.
I'll march up.
I'll indicate to you when you have 1 minute left.
Okay, you just give me the high sign and kick me if I'm over my time. I believe in no temporal trespasses. Begin. On the first point, I think I want to talk a little bit about the two halves. Bill spends very little time talking about the original understanding with respect to the commerce power, most of his time dealing with the takings power. There is a progressive argument that Gibbons and Ogden, which sustained the ability of the federal government to regulate a run between Elizabethtown, New Jersey, and New York City, had very broad senses. But in fact, it was not. On that issue, I'm completely confident. Marshall believed, in effect, that you could not regulate anything internal to the commerce of the state. He didn't even believe that local sales transactions could be so regulated. The way in which the modernists have put the term is he said that the federal power expanded to all things that concern commerce. What he wrote was that it was restricted to all that commerce which concerns more state than one, meaning cross-border transactions. There is a lot of difficulty on the taking side of this debate as to what the original understanding was. I think, in fact, the way we understand that the progressives clearly had to have been wrong about the commerce power is that if they were right, Marshall wrote an opinion which allowed Congress to abolish slavery, because that would certainly affect commerce amongst the several states. There was nobody previous to 1861 who thought you could get rid of that deplorable institution by congressional action. The Commerce Clause was very well understood to be much narrow, and it held that meeting all the way through the 18th Amendment on prohibition and so forth. With respect to property, here I think it's an interesting point as to how you think about it, but I think that there is a third way to think about property which does not involve either stuff on the one hand or value on the other hand, and let me talk about it and then give a couple of illustrations as to what the difficulties are. There is no doubt, for example, that nobody receives property protection against value if the erosion of value comes from competition. I have a store that's worth a great deal of money, and it turns out that somebody opens up a business next door to me. The value of my store goes down in half. I cannot say that my neighbor has taken my property by the reduction in value. And in fact, if it's a government-owned store that does the same thing, the loss in value will have no consequence whatsoever in terms of my private claims. The position is, in fact, somewhat different. It says that any diminution in value is compensable if any of the incidents of property have been taken. It's a much narrower position. And the classical definitions of property talked about the ability to have exclusive possession of property, the ability to occupy property, the ability to develop property, the ability to dispose of property, and to be protected against the nuisances of your neighbor, but having no right to create nuisances of your own. And so then the question is whether or not there's anything short of a seizure of property that ought to count, as though it is a taking by government. And here Bill is quite right. The historical materials are incredibly fragmentary, in large part because governments attempted to do relatively modest things. But now let's just have the following kind of regulation. What we say is, all right, you own property, you can sell it, but you can't use it. Can't get on your own land. We're not going to take it, we're not going to touch it, we're not going to use it. Is that a taking or is that not? And I think virtually everybody comes to the conclusion that if you can't use your own property in any way, shape, or form, and you can't sell it to anybody, but you can pay taxes on it, something very grievously has happened. So the law of regulation and takings emerges from a perfectly sensible system of interpretation, which treats the occupation as the paradigmatic case, and then starts to move on to figure out the way in which these other cases ought to work from it. And there's a last point. I have about 1 minute, I guess. And this is to do with what the question is, when do we start judging the original Constitution? There is certainly the problem of how we do it from 1787. And since there's very little development on the jurisdictional stuff after that period, though it seems to be decisive. But when you get to the property area, and more importantly, I was talking here mainly about economic liberties, there is the transformation that takes place with respect to the Civil Rights Amendment. And that means that you have the Privileges or Immunities Clause, which says that no state shall deny to any person the privileges or immunities of citizens of the United States. The Due Process Clause and the Equal Protection Clause, all of these mandates are extremely broad. And before you start to say about my particular position, my God, he's going way beyond the original intention, remember the following. Every modernist who starts to invoke the religion clauses or the First Amendment, or indeed any of the other kinds of protections, Roe and Wade and so forth, is also going to be engaged in exactly the same enterprise. What happens is our great constitutional clauses are indeed generative. And the history, in effect, tells you what the core cases are, and it's up to a system of interpretation and elaboration used from Roman times on forward to figure out how you move from the core cases by way of analogies. And once you do that, you will see that the modern position of the progressives is inconsistent with that view of interpretation. Thank you.
Dean Treanor.
On the various points, Madison actually thought the federal government could abolish slavery. And actually for him, that's one of the reasons why we had a takings clause, so that if there were abolition, compensation would be mandated. So just on the abolition point. On the Commerce Clause point, which I didn't get to in my opening, there are really two different ways in which people talk about commerce during the founding. One is the way that Professor Epstein has focused on, and that Justice Thomas, in his Supreme Court opinions, focuses on as well, which is kind of a narrow reading of commerce. Commerce is really, as opposed to manufacturing or economic activity more generally. But sometimes it's used in the exact same way. In other words, sometimes commerce is used in a broader way, including manufacturing and economic activity generally. So you have kind of two different ways in which the term is used during this period. And then the question becomes, well, if you've got these two possibilities, what can Congress do? And so let me go back to Marshall. Marshall writes in Gibbons, the wisdom and discretion of Congress, their identity with the people, and the influence which their constituents possess at elections are in this instance, as in many other instances, as that, for example, of declaring war, the sole restraint on which they've relied to secure them from its abuse. They are the restraints on which the people must often rely solely in all representative governments. So the Marshall view in Gibbons is one of deference to Congress as it determines what commerce is, and I think that's particularly appropriate here where the text is not fixed. The final point that I want to make is, Professor Epstein has said that really before the Civil War, the powers of state government were limited. And so we have to reconceptualize what the limits on government should be now that the power of government has expanded. And I guess I would make 2 points about that. One is that what Professor Epstein's his approach to constitutional interpretation is to look at broad principle. What that often means is that the specific practices, the specific understandings, he rejects. So, for example, in the takings area, there are a lot of things that are, according to the book Takings, unconstitutional, that were in fact common during this period, such as price regulation. And the larger point is that they were actually these early states were actually very interventionist. I don't want to use up all my 5 minutes, but since I'm basically done, I can read as much of this as you'll allow me.
You have another minute or so.
Okay. This is a compilation that was in an article relatively recently of the kind of statutes that the New York legislature passed between 1781 and 1801, which is our period. They passed special laws regulating lotteries, hawkers and peddlers, the firing of guns, usury, frauds, the buying and selling of offices, beggars and disorderly persons, rents and leases, firing woods, the destruction of deer, stray cattle and sheep, mines, ferries, apprentices and sheep, servants, bastards, idiots and lunatics, counselors, attorneys and solicitors, travel, labor or play on Sunday, cursing and swearing, drunkenness, the exportation of flaxseed, gaming, the inspection of lumber, dogs, the culling of staves and heading, debtors and creditors, the quarantining of ships, sales by public auction, stock jobbing, fisheries, and the list goes on and on and on. The early 19th century was really kind of a heyday of government intervention. So the idea that this doesn't emerge until after the Civil War, and so only after the Civil War do you need to control government regulation, is just not right.
That last question.
I thank our speakers very much. I hope you all were able to follow everything they said, as of course I was. But I did my best, and you can see they're operating, both of them operating at a very high level. I get, and the rules of engagement, I get the privilege of asking the first round of questions, and I've come up with a few for each. Since Professor Epstein got to go first, I'll start with a few to him and follow with a few to Dean Treanor. Professor Epstein, your book really takes on two main issues, one of which is the Commerce Clause and the scope of the Commerce Clause. The other is the extent to which the Supreme Court does or should have ability to restrict what the states can do in the economic regulation issue. And I'd like to ask you questions relating to both of those and another. The elephant in the room that you don't address is the massive project of the federal government in the latter part of the 20th century and currently, which is the whole social welfare thing, Social Security, Medicare, Medicaid, which I'll posit, although you may disagree, that those things in the pre-progressive era would have been thought beyond the powers of the federal government, and yet it's most of what they do today. Is this something that you have a take on as having been changed by the progressives, or?
Yes, I do. In fact, I have a very strong one. And basically, the take becomes in two parts. The simplest proposition is it's very easy to put these programs in place. If you get a single lapse in judgment by the Supreme Court, you get a major Social Security program. Once it's there, there's absolutely nothing that you can do to disentangle it. I think if you go back and you read the original decisions on Social Security about why it was that they were not takings and so forth and why the federal government had to regulate it, they would show a kind of a jaunty optimism that once we have this program of social insurance, the problem of old age will be handled. All of the implicit transfers that take place across people and over generations were completely ignored. By the time George Bush wakes up in 2005 and sees what's going on, he does not tell you clearly that there's nothing you could do to unscramble this omelet and put Humpty Dumpty back together again. The cross subsidies are so deep that you can't stop them. Same thing with Medicare. And the reason you don't want the federal government to get in these areas, at least if you thought about this clearly in 1935, is they could never keep their promises. They couldn't prevent these programs from becoming monsters that would destroy everything in their path. All the recipients loved the programs. Well, I would love a program if I got $1 in and $4 back every time. The massive transfers are essentially very destructive of employment relations. When they put Social Security in effect in 1935, all of the private plans, including those put in place by firms like GM, were promptly closed down. because there was no way you could keep the one up when the other were put into place. The argument that they made was, look, you can't complain that there's any loss to you from this program. So long as you're better off than you were in the state of nature, anything we do to you thereafter is perfectly okay. That is, in fact, the language of Harlan Fiske Stone, who was a great Columbia law professor. I can't put his particular sins on to Bill. And so I do think, in effect, that if you watch the way these things have worked, the inability to constrain them is something which explains why it is that, A, you don't want a federal government to have that kind of power. It's just too massive. And secondly, if you have no constraints against taxation and so forth, what you have to realize is in a popular democracy, powerful programs of redistribution will essentially become sacred objects, so that to speak against Medicare today is to put your foot on the third rail of politics. I've done it so often at this point that I'm immune to electricity.
And undoubtedly also you're immune from elective office, I would assume.
Oh, a point of office as well. Why stop?
My other big question for you, in undertaking, oh no, I said I'm going to ask you two first and then two for him, if you don't mind.
I never mind.
But be brief on this one, because I need to save a few minutes for him. Okay, one of your things is the Commerce Clause. The other is this economic liberty and the restrictions of the Supreme Court on state economic regulation as exemplified by the Lochner case, which I said at the beginning may be the most reviled case among the progressive types. And I would, as far as I know, few on the conservative or libertarian side seeking to revive it. I picked a quote out of your book, which I'm going to read for this question, and as I think you defined where the Supreme Court should go in regulating the states. Here's the quote. "The basic presumption is that the police power justification for state actions must be directed at some real evil and not some symbolic harm, such as those the progressives found persuasive in cases like, in the list of cases." My question for you is, if the line is real evil, isn't that a extra textual test that gives the Supreme Court carte blanche to go wherever it wants, including Roe v. Wade?
No. Let me explain why. As we talked about originalism, but I think if you go back and you check the title of every 19th century treatise on the Constitution, it has the words police power in them. And yet if you look at the Constitution, the words police power are not there. The question is, why do you have them? Well, the grand tradition of interpretation, again, which goes back to Roman times, is that if you create a liberty, it must always be subject to some exceptions. I have a liberty of action. That doesn't mean I can kill you. You can act in self-defense. And so what happens is when you start to ensure liberty and property, you have to think of the justifications that make it permissible to stop them. Bill gave you a very long list of things, and the question you have to ask is not whether they were there, but how many of them related to health and safety, the explosion of gunpowder, fraud, and things of that sort. I think virtually most of the things on that list fell within that area, and there were some protectionist statute. And I think when we talk about real harms, I mean it in the technical economic sense. Pecuniary externalities, changes in prices from the operation of competitive markets don't count. Symbolic objections to the fact that other people whom you don't like want to get married or engage in religions that you don't like, or practices in employment that you don't like, they don't count either. What I mean by real harms is you could stop fraud, you could stop monopoly, you could stop pollution and all that stuff. And the thing about it is you never want to say, aha, since you could have one limitation on freedom, all limitations on freedom are going to be acceptable. You always have to ask the question, now that you've created an implied exception to every individual guarantee found in the Constitution under the police power, how do you limit that? And the 19th century judges actually sought to do it. The 20th century judges, by God, if they could find a way to create a monopoly, they would give its blessing on that. And for that, I think there really is no kind word that you could say as a matter of policy, and there's no legal necessity for them to do it. You can't gut individual provisions that way.
Give me a chance to ask Dean Treanor one question.
I'm going to stop right up.
Question.
Okay, stop.
I'm sorry to interrupt you.
No, you shouldn't interrupt.
For Dean Treanor, in the period prior to 1918, there was a long process leading up to a constitutional amendment to give the federal government the power to regulate the manufacture and sale of alcoholic beverages. And that, of course, was repealed in the 1930s. Then in the 1950s, 60s, and 70s, the federal government embarked on a gigantic project of the regulation of pharmaceuticals and drugs of all sorts and criminalizing drugs. What is it that changed in the Constitution that made it so they could do that without a constitutional amendment in the meantime? And do you think it was appropriate or they should have had a constitutional amendment?
Well, I mean, I think, you know, what there's the difference is between the understanding of the Commerce Clause, right? In other words, you know, the prelude to Prohibition, there's you know, you have a very limited conception of the Commerce Clause represented in the Supreme Court jurisprudence. And so that's why, you know, the amendment is couched in a broader term to make sure that Congress will have a broader authority, okay? Whereas later, in the 50s and 60s, commerce has been redefined, okay? And so, you know, again, the question for me is when it's redefined, you know, are they going back to the original understanding or not? Because, I mean, there clearly is a change. So to frame it in terms of Professor Epstein's book, you know, did the progressives rewrite the Constitution? You know, at one level, they obviously did. The jurisprudence of the Supreme Court in 1945 is dramatically different from the jurisprudence of the Supreme Court in 1925. So, I mean, I think that's really unquestionably the case. And it's not an incremental change. It's a revolution. And the question is whether the revolution kind of takes you back or not. And then, you know, and then the other point that I would make is...
I'm sorry to cut you off, but I think our tape is about to run out. So I would like to thank everyone all for participating in an extremely enlightening debate, and thank our panelists.